20, sir. Yes, Mr. Pandey.
Yes, my lord. Yes, my lord. So, my lord,
Sorry, got a bit delayed due to some work. Yes. Yes.
Sorry. My lord, up till now, I have invited your lordship's attention to the fact that the present contract is a terminable contract. And yes, my lord.
Yes, one second.
Yes, my lord.
Two pages in this one. One second, just give them. Okay. Yes.
Yes, my lord. So up till now, my lords, I have invited your lordship's attention to the fact that this contract is a terminable contract. And the second point, my lords, I have tried to canvass is that the correspondences itself indicate that the performance of the contractor was abysmal, and it justified the action taken by the corporation to terminate the contract. Third, in this regard, my lords, I have shown the annexures which are there with the counter affidavit and a few correspondences which are there in the writ petition. In this regard, my lords, I may just invite to two crucial pieces of correspondences which are there in the writ petition, which show, my lords, categorical admission on their part that the delays have been committed by the petitioner.
Yes.
And my lords, invite your lordship's attention to page 212 of the writ petition. This is annexion number 26. Letter dated 5th August 20.
Yes.
212, my lords. Now, this is a letter, my lords, emanating from the contractor to the chief engineer.
Meeting.
Yes, my lords. Regarding review meeting of substation package so-and-so held on 6 July 2023. Now, first paragraph itself, my lords, indicates what is the reason. Now, it says that we would like to raise few points of MOM held on 6 July 2023 regarding review meeting in reference to point number 1 of MOM to the review meeting on substation package ADB dated 6 July 2023 regarding slow progress at all substations. We would like to bring into your kind attention that we had cross-questioned our employees working in Meghalaya project that after sufficient fund given to subcontractors, why we are not able to complete even one station. Thereby completely we felt like a conspiracy and resigned, due to which our further progress at that project hampered. Now we have appointed all new officials, site engineers, site supervisors to speed up the progress. We are still trying to retain one of our heads who has been in this project since the beginning. Sir, we assure you that we are taking it very serious, promise to you in the meeting dated 6 July. So, my lords, in this regard, the delays which have been committed, they are admitting to the fact that their house is not in order and they are not able to meet up with the requirements of the contract.
My lords, since my lords are on this page, I request my learned friend to also complete the letter, because it's a very incomplete picture. Since
let them complete. Yes, Mr. Pandey.
Since it's this letter itself, I thought, my lords, he should read paras 4, 5, 6 also, because this has to be seen in the context of that.
Let him complete. He didn't disturb you. Yes.
Very well, my lord.
Yes, my lords. Now, in this context, my lords, this is not an isolated sort of event, because after I issue the termination notice, they reply to that termination notice, my lords, and they accept that the delays have been committed by them. In this regard, my lords, I will invite your lordship's attention to page 237, which is annexion number 32.
2?
237, 237, Annexure 32.
Yes.
Now, my lords, this is a letter January 2024, which is after the termination letter, which is dated 15th of December 23.
Yes.
So, and this is in a way, my lords, their response letter to my notice of termination. And it says, we thankfully acknowledge your receipt of your letter dated 15/12/2023, wherein your good self has expressed your displeasure regarding slow progress of work against the above contract. Sir, we agreed that there has been initial delay on our part in starting the project. But we still, if you give us additional 6 months, we are confident that we can try our level best to execute project with good quality manner. Sir, we thank you for the extension of time given by you to complete the project till August 2023. Despite the above, we could not complete the project as per your expectations within the stipulated time period, due to which various factors and circumstances are responsible, such as: first, due to global pandemic COVID-19, my entire action plans to complete the project on time got disrupted. Two teams selected for the project kept breaking up again and again, and we had to organize a new team again and again. Sir, initially we found the repeated resignations given by the employees to be circumstantial, but after studying, it was confirmed that a conspiracy was being hatched by some people, which a vicious circle was being carried out to influence our project. Due to the above reasons, we could not achieve the desired progress, and the project was also affected. So, Milos, what conspiracy? How can a public corporation keep on extending the contract where, admittedly, there has been delay in completion because there is some conspiracy which is going on, and your teams are getting broken because of that. So, and thereafter, Milos, again, it goes on due to global pandemic. Our projects are running in other states were also adversely affected. We have suffered huge financial loss. Due to this, it became difficult to purchase material on time. Although we have made every possible effort to ensure that everything went well, the efforts made by us in this regard are also in cognizance of the project. And thereafter, Milos, there are certain other reasons they have indicated in respect of inspection and all.
Those are being conveniently left out to be read.
No, the issue here is that here is a contractor which is admitting there are delays. There are delays because it is not able to muster up an entire team. There are certain conspiracies which nobody knows that what are those conspiracies. In this light, Milods, our action of terminating the contract where there is 8% to 13% of work completion is absolutely justified. So, Milods, that is there. And now, Milods, in this context, just sees the contractual provision, because at the end of this entire contract, their remedies are governed by the contract. And I will invite your Lordship's attention now to clause 44 of the contract, which provides for remedies for the contractor. 155, page 155 of the writ petition.
Forty-four clause 45.
Both, Milods, 44 and 45, both are relevant for, because in the event claims,
Yes.
then 44 can be resorted to, and it says if the contractor consider himself
Yes.
entitled to any extension of time for completion, because here one of the reliefs is extension of time for 6 months for completion and or any additional payment under any clause of these conditions or otherwise in connection with the contract, the contractor shall submit a notice describing the event or circumstance giving rise to the claim. The notice shall be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. Because then there is a entire mechanism which has been set forth by the contract. It's a standard form of contract followed in all ADB projects, which is there in this contract. And then below 45, there is an arbitration disputes and arbitration clause. The parties shall seek to resolve any dispute amicably by mutual consultation.
Yes.
If either party objects to any action or inaction of the other party, the objecting party may file a written notice of dispute to the other party, providing in detail the basis of the dispute. The party receiving the notice will consider it and respond in writing within 14 days after receipt. If the party fails to respond within 14 days or the dispute cannot be amicably settled within 14 days following the response of that party, clause 45.2 shall apply. The parties shall use their best efforts to amicably settle the disputes arising out of or in connection with this contract. So it's a complete waterfall mechanism because it is provided. First, amicable settlement, then when two relates to conciliation. If parties have failed to resolve their dispute or difference by mutual consultation as per clause 45.1, then either the employer or the contractor may give notice to the other party its intention to commence conciliation/arbitration as herein provided as to the matter in dispute, and no conciliation and arbitration in respect of this matter may be commenced unless such notice is given. So, and then below this goes the contractor here, instead of availing the remedies under the contract, is approaching this honorable court, asking this honorable court to decide disputed questions of fact, who was responsible for delay, who was not responsible for delay. That, Milods, in the kind of documents and the kind of exercise, Milods, this honorable court is exercising, it may not be possible conclusive finding on those issues. Milods, in my humble submission, cannot be raised before this honorable court. Now, Milods, in this context, just sees one aspect, that the action of the corporation, Milods, is also in a way justified, because we have all the more reason. Now they have filed a rejoinder affidavit and they have placed reliance on certain orders which had been passed in the state of Himachal Pradesh Transmission Corporation, Milods. Kindly seize that order, Milods, because that shows that the contractor is basically habitual in not performing the contract, Milods. Rejoinder affidavit, page 72. This, Milods, is HP Power Transmission Corporation. They say that this was revoked, but the contents, Milods, indicates that how the contractor has been performing its contract. I'll just invite your lordship's attention to page 72A.
Yes.
Second paragraph, it says, whereas in response to show cause notice dated 30/9/2023, you had responded to letter number so-and-so dated 13/10/2023 and had committed to remobilize the site as well as expedite the pending supplies. Consequently, HPP TCL took notice of your commitments and released 95 lakhs amount on 18th October 2023. However, your performation of obligation after 18/10/2023 has been dismal till date. There has been no diligent effort on your part to either complete the project or initiate supplies. There is no adherence to the commitments made by you regarding remobilization of labor at site as well as efforts to expedite the pending supplies. There is no update regarding the payments made by you to the vendors of the project against payment of so-and-so released to you on 18th October 2023. So, my lords, in this and lastly, last paragraph, in view of it emerged that you are not interested to complete the work under these circumstances. I am directed to intimate that the contract for construction of so and so is hereby terminated. So, my lords, now these are the documents that the petitioner has supplied, and it's a different story, my lords. It may have been the corporation may have taken note of it and revoked it for commercial considerations. But the situation is that it's a consistent practice of the petitioner to dilly-dally in completing the projects. And if the corporation in the instant case is not in a position to give a long rope to the contractor in such situations. So, my lords, in overall totality of things, the action of the corporation to terminate is justified. There are enough contractual provisions for the contractor to resort to instead of availing the writ remedy, my lords. And in my lords, and in this context, my lords, I may just place certain orders of this honourable court, which will, my lords, assist your lordship.
Compilation.
Well, these are independent orders, my lords. First order which I may bring to your lordship's notice is of order dated 23rd of July 2024.
Yes.
This is Marbanyang Enterprise. Milos has Marbanyang Enterprise?
Yes.
Yes, Milos. Now I'll because Milos, in a similar situation, your lordships were faced with a similar situation in paragraph 18, Milos.
Eighteen.
18. As such, looking into the totality of facts and circumstances of the case, this court notes that the petitioner failed to avail arbitration which had been provided in the contract agreement itself, which at this belated stage by operation of law cannot be taken recourse to. Further, no civil proceedings or for recovery of any alleged dues had been instituted within 3 years of the acknowledged payment, receipt of final payments to money suit, except for exceptional circumstances which the petitioner would have to demonstrate. The other factors of delay, disputed facts, and absence of any clear outstanding due also come in the way of this court in exercising jurisdiction of discretionary powers under Article 226 of the Constitution of India. So, Milords, disputed question of facts, availability of alternative remedy is in fact, Milords, equally applicable in the instant case also. Milords, then I may place one judgment of the division bench of this honorable court, Milords, in the case of Pawan Casting, which is an order dated 5th of September 2022. This is by Milords division bench and para 14, Milords. Because that case also, Milords, pertained to the power corporation, and there was also a terminable contract there. So it is, Milords, relevant in that sense. 14, Milords, in any event, the agreement between the parties or the MOU or the order passed by the State Electricity Commission provided for the dispute between the parties to be referred to Regulatory Commission for adjudication. Once the writ court had noticed that the appellant in this case was, in terms of the agreement with the writ petitioner agreement, and the appellant had exercised its right under the relevant clause and even indicated reasons therefore, when the basis of the termination was sought to be disputed on the ground that the assertion as to failure to meet the minimum load factor was incorrect, the writ court ought to have exercised restraint and not gone into the matter, in effect disbelieve the appellant's contention that the minimum load factor had not been met. And Milords, then it goes on to the various contentions which has been taken. But the sum and substance, Milords, is that when there are reasons afforded for termination, Milords, then there has to be some restraint, Milords, in these sort of matters, Milords. Now, Milords, in a similar situation, I may just highlight a Calcutta High Court decision, because the petitioner has relied upon judgments of ABL Corporation. Milords, all these judgments were considered by the Calcutta High Court and the Calcutta High Court, my lords, after considering the decisions in paragraph 18, this is a judgment of 2023, ILED Foundation and another versus State of West Bengal and another. This is by Justice Sabyasachi Bhattacharya, Lords, para 18.
Yes.
ABL International, my lords, has been placed reliance upon. It says, my lords, para 18, in ABL International Supra, the Supreme Court observed that the writ court can interfere in appropriate cases involving disputed questions of fact and that there is no absolute bar in interference. It has also been observed that in some cases, oral evidence can be taken. Naturally, the respondents have placed strong reliance on this judgment. 19. The said judgment laid down the factual matters. The remedy of Article 226 lies in certain cases and is not absolutely barred. The stress in the said judgment was on the proposition that merely because disputed questions of fact are involved, the writ court may not shy away in all cases. 20. However, it is evident from the judgment cited by the parties, the writ jurisdiction has evolved considerably since thereby diluting the bar of alternative remedy. However, the said bar does not altogether negate the self-imposed restriction of constitutional courts in case of availability of alternative remedy. The jurisprudence which has evolved in this field, as evident from the judgments relied by both parties, is clearly that interference under Article 226 by the High Court is circumscribed by certain tests. If arbitrariness, palpable illegality, violation of witness-peri principle, perversity, malefice, unreasonableness, or violation of any fundamental right, the writ court can interfere. However, the Supreme Court has not laid down any, and in every case where there is an existence of an alternative remedy, the writ jurisdiction can be invoked despite such remedy as a matter of rule, which would tantamount to erasing such alternative remedy from the statute books. So, my lords, today what they are suggesting is that despite the contractual remedies being available, despite my lords, they can their right to raise those disputes in terms of the contract being available, they want to knock the doors of this honorable court. My lords, then it goes on to the analysis of how the case is fit because there are disputed questions of fact. And my lords, even in this case, with each and every word being said in this matter, my lords, it is becoming apparently clear that the matter is not fit for adjudication in a writ proceeding, my lords. So, my lords, I am placing reliance upon these judgments.
Yes.
And lastly, my lords, last point I would say, my lords, that this is a case where the termination happened, my lords, on 15th of December 2023.
1 second.
And the
termination was on
15 December, my lords.
Okay.
15 2023.
Yes.
And my lords, they have approached this honorable court, my lords, in the first time this matter, my lords, lands up before this court is 24th of April 2024. So there is my lords, they have taken their own sweet time in approaching this honorable court. And my lords, in that context, my lords, they are not entitled to any remedy, equitable relief from this honorable court, my lords.
Right. Anything else to rejoinder, or will close the matter?
Yes, my lords, I have a long rejoinder, my lords.
I won't permit that. Only on law. Not on facts.
Yes, only on certain factual aspects, my lords. He has taken. My lords will not. My lords have heard him in detail
we have given a very patient hearing. This court usually does not hear. Mr. Pandey will testify that. My hearings don't last more than 45 minutes.
This I understand, my lords, is a final hearing. I have come completely prepared. My lords will give me some time to argue, my lords. on law as well as on facts, my lords, because there is
rejoin us on law.
No, my lords, on facts also, my lords, because what is being projected here, my lords, is that these are disputed questions of fact. Let me, my lords, make it very clear that as for I am before my lords challenging an arbitrary action of the state, which has in fact become stronger with the arguments of my learned friend, which has gone on to say that we had the power to terminate and therefore we have terminated. My lords, I had in my opening, my lords, I had stated that there was a delay with respect to the land being given. There was a delay with respect to payments being made. There was delay with respect to our calls for commissioning, calls for inspection not being answered to. My lords, they have not disputed any of that. They have no even after the show cause notice. My lords, will kindly turn to page 205, which is one of the letters that my learned friend had read.
Yes, 205.
My learned friend had read the first two paragraphs. The third paragraph onwards.
During this period. Yes.
The para after that. So we would also like to bring to your notice, we have submitted GTPs of the suppliers from where we are supposed to get materials, but approval of the GTPs have taken a long time, in some cases 2 months. We would also draw your attention, we have submitted inspection calls to your esteem office, which are pending for more than 3 months. A material worth 2.5 crores is lying pending for physical inspection and billing since October 2022. Moreover, material worth 28 lakhs are in transit, which are expected to reach the project location by 20th May 2023. As a nomination for inspection call is taking long time, is affecting us. As you know, project is not applicable. Vendors are raising price of materials since the price of raw materials like steel, aluminum, copper has raised. We also want to inform you by end of May 2023, we raised inspection calls for GI structures, and by June 23, first week, we will raise inspection calls for 2 numbers of such and such. In our project, so my lords, inspection calls are being raised by us, which are not being answered. Disarms us in completing the project, my lords. My lords will note that as far as the delay in, I pointed out that though the land sites were made available only as late as June 22, my learned friend in his counter has given no justification for it, has given no justification for the fact that payments were made 131 days in delay, my lords. And my learned friend also said this is an ADB funded project, and I do not know if the amounts have been made available with the respondent, why the amounts were not paid to us in time, my lords. None of this has been responded to by the respondent in any manner. They only say we have lost confidence, we have terminated. This itself, my lords, is completely arbitrary, completely unreasonable, because I have pointed out at least 8, 9 aspects where they were supposed to revert, they have not reverted, which is why we were in a situation where we could not complete the project. However, they go on to use that to say we have not done any work and we have lost confidence. The loss of confidence is only because they have not answered our calls for inspection, etc. My lords, also this, I want to go through this to also show what I had reiterated, that civil works had been completed in large measure. My lords, will see page 206. Yes. Kharkutta PSS, boundary wall 22.10 RM completed, RRM work completed, water supply completed, barrack completed.
You've seen that, yes. Right, then?
My lords, but I must, because my lords, in terms of, it was only after we raised the control station, we raised the civil works, that we wanted to order machinery to place in, my lords. I had read from my lords para 9 of the rejoinder. This shows that we as a diligent contractor, my lords, had done what is the groundwork, which in terms of financials may not, it might not aggregate to too much. Therefore, the project, they are harping on the fact that only 13% of the project work is complete. We could have simply ordered the material, which again we could not complete ordering of the material because they did not take our inspection calls. They did not approved vendors that we had placed before them. And that is the disability that we were placed with, which they arbitrarily thereafter they use that to illegally terminate the contract, my lords. Therefore, these are not disputed. I am not, before my lords, asking for any payment. These are not disputed questions of fact which can in any manner be addressed in an arbitration proceeding. These are questions which go to the reasonableness of a state action, illegality of the state terminating my contract despite me being performing diligently over 2 years. And I have stated before my lords the reasons why I was not able to complete it, my lords. So I am questioning, my lords, the arbitrary action of the state. I am not, before my lords, claim an amount under the contract. We have been relegated before an arbitral tribunal. But here, my lords, I'm questioning the arbitrary action of the state, which I'm substantiating I'm looking only at the letters to demonstrate the arbitrariness of their action, my lords. It is not with respect to a paisa which could be relegated to arbitration. My lords will then continue to see page 207. So one more thing, that our 10 sets of construction drawings have been approved long back from your esteemed office. But sir, lastly, we are unable to give manufacturing clearance to the supplier of GI structures, as we have been asked to redesign the tower drawings with double beam design by your officials verbally. Sir, this has taken a lot of time for us to redesign the same, as no designers locally available which has done this design. Lastly, we have got a designer who's making the revised design, which we will submit for your approval next week. After approval from your office, we will give manufacturing clearance to the supplier and we will try to supply it at the earliest. Due to these mentioned issues, we are unable to procure major materials for the project and also unable to supply bills against the same. We put in our best efforts to work towards achieving these objects as a team along with your good selves. We sure you appreciate all the good work which has been done by working together with you and receiving the best support from. And then again, we laid out, my lords, with their cooperation, if their cooperation was forthcoming, how we could have completed the project. However, there was no cooperation from them, my lords. My lords will then go on to the next document, which is page 2 meeting. I will read the last part, which again reiterates that we had request para 6, my lords. TKC has also requested for nomination of pending inspection calls, which were submitted to the Chief Engineer Projects Office, such that they can procure the materials at the earliest. As on date, nomination for 4 numbers of inspection cells were pending, that are of GI structures, ACDB, LT cubicle, LT cables, conductors and insulators. My lords, how is the contractor expected to complete if the necessary nominations and inspections are not being done by the respondent, my lords? Respondent has offered absolutely no explanation for this. They simply say, we call you for a meeting. We have no confidence in your ability to complete, completely ignoring why we have been placed in this situation, my lords. He has also requested for approval of civil estimates submitted to the Chief Engineer Projects Office on 8th June 2023 against rectification of CRD and barrack of Songsak, Samanda and Mendipatha substation. These estimates were duly certified by EE Projects Williamnagar and SE Projects of Garo Hills. TKC informed that within 7 days from receipt of approval, they will start rectification work. My lord, which also has not come. TKC also informed that they have to procure 12 numbers of 30 volt, 33 kV VCBs from Messrs. Popular Switchgear as per approved GTP and BI issued by MEPDCL. They have requested that this 30 volt is mentioned in the NIT and the same GTP is approved by all concerned officials of MEPDCL against which they have procured the materials. So corrigendum be issued by MEPDCL so that billing against the same can be done. This, my lords, involves an amount of 1.85 crores. However, no corrigendum is issued. Therefore, we are not in a manner entitled to go forward with respect to this. So all of these, my lords, we pointed out specifically which were impediments in us
Okay,
completing
anything else?
My lords, there are two. My lords will appreciate that so the state's action in simply saying we have lost confidence while they have
Not
not
enough.
performed what
I
they
say
were required to do.
reasonableness. There's no reasonableness in the action. It's hit by arbitrariness. Yes.
Yes, my lords.
You're not making any claim for any amount, and so not arbitral
Yes.
dispute,
Milords,
and so you're seeking
Ma-
revocation or termination. That's it, on the ground of.
Yes, my lord. Again, page 213, same thing, my lord.
Right.
Again and again, we say, please make the inspection cause. Please give us approval for the civil estimates. Please give us the go ahead for procuring the switch gear. Then we can go on to complete. They do not. These are, my lords, letters of August. They do nothing. They do nothing for us to facilitate completion of the project. And thereafter, they say we've lost confidence, and in December, they simply terminate the project, my lords.
Right.
interestingly,
Yes.
the Milords 2 and 6, the letter where we say that we have lost confidence has not been challenged. 2 and 6 has not been challenged.
It is culminated in the termination letter, which we have challenged, my lords. And I did not interrupt my learned friend. My learned friend may extend me the same courtesy.
Yes, it's merged, doesn't
My
it?
lord, my lords, then I'm very shocked, my lords, that my entire reason for coming here is a process which my learned friends, they have not sought to justify the retender process. They have not said how it is in the state's interest to go through the retender process. And the second reason I am before my lords is because I am squarely challenging the retender process, which will have an effect on the exchequer, which will completely delay the project. In fact, my lords, the ADB project, I have put in my rejoinder the documents of the ADB loan, which says that the loan is in fact valid till 28/2/2026, and the completion date of the project is 31/8/2025. My lords will see page 73 of the rejoinder, which in fact cannot be achieved under the tender process, my lords. However, which can be achieved if I am given a further extension, because most of my work is done. The civil work is done. As long as they start making the payments, I can have the equipment procured and completion can be achieved, my lords. The managing director of my client, my lords, is personally present before my lords, so that if my lords want to take an undertaking from him with respect to the time period for the completion to show diligence, he is there before my lords. My lords will see that this shows an complete confidence in us that we will be able to complete the project if my lords give us some more time.
Right.
And on this, my lords, they have also not reverted back at all about why the state council has not addressed the issue of retender at all, has not justified the retender. That is one of the main planks why we are before my lords in a writ proceeding, my lords. They have not adverted to that at all. My lords will see also, now there are specific allegations which were made about us suppressing material, about us misappropriating material, my lords, which is absolutely factually incorrect. These are facts which are stated only to prejudice and mislead my courts, and that is extremely unfair, my lords. My lords will kindly turn to my rejoinder, where point by point I had given my reply to each of these points, and there is no substance, my lord. They had made an allegation that certain
Leave that
amounts
aside. Leave that aside. We're not going to consider that. We're only looking at the manner of termination. That's all.
my lords, but they have also cast aspersions on because they kept saying, please look at their conduct, and my lords allowed them the liberty of reading through each of those allegations. So it is my duty, therefore, my lords, to place before my lords our response to that. My lords will kindly turn to page 10 of our rejoinder.
Yes.
Para 7G. I will only read the relevant parts. This was read by him in detail, which is why I have to counter it, my lords. Para G, the contentions in para 7.4 that earth mat material for which 1,676,000 was paid is not available at store. and that the petitioner has misappropriated the amount without supplying the material is fallacious and entirely concocted. My lord, the state to irresponsibly make such an allegation is absolutely unfounded. In fact, the said allegation contradicts the respondent's own table showing the final status of work as on 15/12/2023, produces an extra R7 of the affidavit of in opposition, which states that till now only earth mat material supplied to the store but not erected of the respondent corporation had issued the material inspection report confirming that the earth mat material was received in good condition and duly entered into stock. It is also submitted that the bills raised by the petitioner is verified by SMAC, a third-party organization, before the same is cleared, and paid by the invoice raised for supply of earth material was duly verified by SMEC. Hence, it is unfounded that supply. Then, my lords, this NI Act proceedings, which has absolutely no relevance, has again been thrown up on various occasions, my lords, to prejudice this court. Next, my lords, I will read. My lords, where the bargaining power between the state and me, my lords, is evident. Where in parts of my letter which shows my bona fides, where I have said I will, if I am given time, I will continue to perform the project, is drawn against me.
Yes. Heard. Judgment reserved.
My lords, no, I have not completed. I have to show, yes. I have to read some parts of the judgments on maintainability. That is extremely crucial, my lords.
I'll look the judgment myself. Yes.
My lords, will turn to the compilation of judgments that I have given.
We understood the main.
No, my lords, but I should point out my lords, I have given a compilation of judgments. My lord will then turn to the last.
That earlier on.
No, but I have not read it. My lord, and I have
ABL International, para 27. Joshi Technologies, para 69, then MP Power Management, para 82, 82.3,
turn to the last judgment,
8.19.
Turn to the last judgment.
Joshi. Yes.
My lords, I mean, I am a little perturbed, my lords, that I am not being given some claim to at least I have made preparations, I have given written submissions to my lords.
Yes, I mean, that's why you're going to submissions, yes, it does suffice. The only thing is that now you've already placed your arguments and we understood.
No, my lords, I am here, my client is there. I may be given the liberty to address my lords according so that I get the
no more submissions, yes, on facts. Yes. Yes. 82 point para 82.
No, I was not reading para 82, my lords.
Yes.
Para 41.
Public law remedy.
Page 185, my lords.
Of compilation judgments.
Yes, yes. I will start with the last and the most latest judgment of the Supreme Court.
Okay. Yes.
This is on the point, my lord, that disputed questions of fact or a contractual matter should not engage the time of a writ court.
Yes.
My learned friend has not at all addressed the point of retender. That goes unrebutted and therefore admitted that the retender will cost the public exchequer large amounts of money, and also the project completion will be delayed beyond what is envisaged by the ADB. This has not been addressed at all and therefore will be deemed to be admitted, my lord. They have not gone to
judgment. 185, yes, is the middle part of the judgment.
Yes.
Which para?
Para 39. Thus, for a period of time, the courts recognized that there was a bright line distinction between a state or its instrumentalities could be said to be acting in executive capacity, and when it could be said to be acting in its private capacity with the existence of contractual relation inter se, the parties being determinative factor. Whenever there is a contract, the state's relation and all its actions were said to be within the field of contract, that is with the realm of private law, and the courts would reside from interfering with the same under writ jurisdiction or embarking upon such a judicial review of actions. Such reluctance on the part of the court stemmed from its understanding that state or any of its instrumentalities must have the flexibility or discretion to take decisions that are that is the best interest of public and efficient governance. Government, being decision maker of the state, is said to be the best judge of when a contract or an agreement is in its interest and by its extension interest of the public, and as such, court should not interfere in state's discretion to award or terminate contracts. One another reason why contractual disputes are precluded from being exposed under the jurisdiction of the courts was due to summary nature of such proceedings, which do not allow an exhaustive review, unlike civil suits. Now, the court dispels this notion. This para 41, this is what I want to emphasize. This simplistic approach of courts in deeming every act and action of the state which was complained of as nothing more than a contractual dispute or a case of breach of contract often led to the state abusing its position and acting unfairly under misconceptions such as award of contracts or tenders, where nothing but a largesse, a generosity bestowed upon citizens, which can, on its own whims, choose to deny, alter, modify, or take away without any consequences. This led to a conflation of power with duty and resulted in every arbitrary exercise of power by the state under the guise of a contractual dispute to remain unchecked and undisputable before courts and out of the reach of judicial review, undermining the rights of the citizens to have their interests safeguarded and protected. Then it refers to certain judgments. I will not go into that, my lords. Then come to para 43, which is under the heading Concept of Public Law Elements, Scope of Judicial Review in Contractual Matters. Over a period of time, the courts recognize a crucial role of judicial oversight in preventing abuse of power and maintaining public confidence in the administrative process. Courts develop various doctrines and principles to guide their reviews, such as principles of natural justice, reasonableness, and proportionality. These principles ensure that the administrative actions are not arbitrary, discriminatory, or capricious. By enforcing such standards, the court also ensured that the rule of law is maintained and the individual rights are protected. The interplay, then, my lords, I will take my lords straight away to these are the various judgments where on contractual matters courts have gone into, but I'll take my lords straight away to para ABL, which my learned friend referred to. I will read para 51 of this, my lords, where the extract from ABL is there. Para 27 of ABL is extracted. I'll just read that from the above discussion of ours. My lords are on page 191.
Right. Read. Yes.
Yes. From the above discussion of ours, the following legal principles emerge as to the maintainability of a writ petition. In an appropriate case, a writ petition as against a state or an instrumentality of a state arising out of a contractual obligation is maintainable. Merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse or entertain a writ petition in all cases as a matter of rule. A writ petition involving a consequential claim of consequential relief of monetary claim is also maintainable. Then, my lords, I go on, my lords, to, in fact, the para 54, my lords, extracts the paragraphs of Joshi Technologies, which I had marked, my lords. But I'll not trouble my lords with that. I will go on to para 55, which, my lords, is the judgment in MP Power Management versus Jabalpur versus Sky Power. Yes. Para 53 of that. When the offending party is a state, in the other words, the contention is that law in this field has witnessed an evolution and what is more, a revolution of sorts and a transformatory change with a growing realization of the true ambit of Article 14 of the Constitution. The state, he points out, cannot play Dr. Jekyll and Hyde game anymore. Its nature is cast in stone. It's of the activity it indulges in. It will continue to be haunted by the mandate of Article 14 to act fairly. There has been a stunning expansion of the frontiers of the court jurisdiction to strike at state action in matters of contract based undoubtedly on the facts of the case. It remains open to the court to refuse to reject a case involving state action on the basis that the action is per se arbitrary. My lords will recall that my arguments are that all through my treatment by the state has been unreasonable and arbitrary right from the outset, where land was not given to us, where payments were not made to us, and subsequently, in rather than cooperating me for correction and remedying the delays, they have simply acted unreasonably in not answering my calls for inspection, as well as approval, and then finally reached a point where they say that you have not performed, we have no confidence in you, rejected all their duties under the contract, and simply thrown up their hand and said you have not adhered to the timelines, and therefore we are terminating, my lords. Thereafter, my lords, page 197. Yes, the last. I'll not. My
Page
197, the last 197. This is in fact an extra Pradesh judgment. This is Justice K.M. Joseph's judgment.
Yes.
In case subpara 12. In a case, the state is party of the contract, breach of contract is alleged against the state, a civil action is the appropriate forum, is undoubtedly maintainable. But that is not the end of the matter. Having regard to the position of the state and its duty to act fairly and to eschew arbitrariness in all actions, resort to constitutional remedy on the cause of action, that action is arbitrary, is permissible. Then, my lords, I'll go to para 56, which this is from the same judgment. After quoting, my lords, extensively from all judgments which dealt with exercise of writ jurisdiction in contractual matters, the court says, what can be discerned from the above is that there's a considerable shift in the scope of judicial review when it comes to a contractual dispute where one of the parties is the state or its instrumentalities. In view of the law laid down by this court in ABL, Joshi Technologies, MP Power, it is difficult to accept the contention of the respondent that writ petition filed by the appellant before the High Court was not, and the relief prayed for was rightly declined by the High Court in exercise of its writ jurisdiction. Where state action is challenged on the ground of being arbitrary, unfair, or unreasonable, the state would be under an obligation to comply with the basic requirements of Article 14 of the Constitution and not act in an arbitrary, unfair, and unreasonable manner. That is the constitutional limit of their authority. This is a jural postulate of good faith in business relations and undertakings, which is given effect by preventing arbitrary exercise of power by public functionaries in contractual matters with private individuals. With the rise of social service state, more public-private partnerships continue to emerge, which makes it all the more imperative for courts to protect the sanctity of such relations.
Yes.
My lords, thereafter, specifically on courts exercising writ jurisdiction for termination of contract, I draw my lord's attention to paras 128 and 129 of the same judgment.
128. 128.
Yes, my lord. Yes.
Yes.
Cancellation of a contract deprives a person of his very valuable rights and is a very drastic step, often due to significant investments having already been made by the parties involved during the substance of the contract. Failure on the part of the courts to zealously protect the binding nature of a lawful and valid tender would erode public faith in contracts and tenders. Arbitrary termination of a contract creates uncertainty and unpredictability, thereby discouraging public participation in tendering process. Where private parties perceive that their contractual rights can easily be trampled upon by the state, they would be dissuaded from participating in public procurement processes, which may have a negative impact on such public-private partnership ventures, and ultimately it is the public who would have to bear the brunt, thereby frustrating the very object of public interest. We caution the public authorities to be circumspect in disturbing or wriggling out of contractual obligations through means beyond terms of contract in exercising the executive power. We do not say for a moment that the state has no power to alter. If the state deems it necessary to alter or cancel on the ground of public interest or change policy, then such considerations must be bona fide and should be strictly reflected in the decision-making process and also in the final decision itself. We say so because otherwise it would have a chilling effect, as participating in winning a tender would tend to be viewed as a situation worse than losing one on the threshold. My lords, I therefore conclude saying that, my lords, we are before a writ court because this is a public law remedy that we are looking to from my lords. There's an illegal termination of the contract on the basis of arbitrary, unreasonable actions of the state. There is a re-tender process, my lords, which involves public money, public exchequer, and a delay in the project. And we are here committed before my lords to complete the project on time. We can, if my lords require, give again, but that of course would require a cooperation from the respondents, which has been absent at least in the past year, my lords.
Right. Yes. Hearing of the judgment reserved. Yes.
My lords, there was an interim protection that was given with respect to the...
Reserve the judgments will come on a day or two. How many weeks has passed? Nothing has happened. Yes.
My lords, yeah, if it is a day or two, that is okay, my lords, but otherwise we may be protected against the encashment of the bank guarantee till the judgment is pronounced, my lords. For that, there is a separate IA that has been filed by us, my lords.
Don't worry, they won't do anything. They haven't done anything for so long, since last time also. They didn't fight a jointer.
That IA is 149, obliged, my lords, obliged for the patient hearing.